Welcome to Pro Legal Minds. In this session, we're discussing moonlighting versus dual employment in India, one of the most debated topics in 2025. We'll cover every aspect: the law, the case laws, employer and employee perspectives, HR policies, remedies, and real-world examples. Let's begin. In this guide, we'll cover the essentials you need to understand workplace compliance. We'll begin with the statutory baseline, the bare acts and their meaning. Next, we'll look at authoritative case law to see how courts have applied these provisions. We'll explore employer rights, what employers can and cannot do, and equally, what employees should know to protect themselves. We'll provide HR policy templates and practical compliance checklists for day-to-day use. Finally, we'll examine dispute remedies from both the employer's and employee's perspective. This guide is designed to equip you with both legal knowledge and practical tools for effective compliance. In India, there is no single blanket law banning moonlighting. It depends on three things: the employment contract, the labor statutes that apply, and whether the side job causes a conflict of interest. During employment, exclusivity clauses are valid. Post-employment non-competes are mostly void under Section 27 of the Indian Contract Act. For factory workers, dual employment is statutorily barred under Section 60 of the Factories Act. So, moonlighting is a legal gray area. Enforceability depends on context. Section 27 of the Indian Contract Act 1872 states, "Every agreement that restrains a person from exercising a lawful profession, trade, or business is void." What does this mean in practice? Indian courts treat post-employment non-compete clauses with suspicion. They are generally considered void, except in limited cases like the sale of goodwill. However, during the period of employment, employers can enforce clauses that require exclusivity, such as whole-time attention to the job or restrictions against working for another employer. These are valid so long as the terms are clear, reasonable, and supported by proper contractual consideration. In short, employers cannot restrain employees after they leave, but they can ensure loyalty and exclusivity during the contract term. The Factories Act, 1948, Section 60, no adult worker shall be required or allowed to work in any factory on any day on which he has already been working in any other factory. Section 60, Factories Act, 1948. What Section 60 means in practice? Section 60 prohibits double employment for adult workers in factories. The provision is protective, limits working hours and health risk. It is strictly applied to factory workers, i.e., manual production employees. The provision does not automatically apply to knowledge workers, IT professionals, or employees outside the factory industrial establishment context. Now, let's look at the Industrial Employment or Standing Orders Act of 1946. This law requires certain industrial establishments to create certified standing orders, essentially formal rules of employment. These cover conditions of service, attendance, conduct, misconduct, and procedures for termination. The model standing orders even allow employers to include express prohibitions against dual employment. What does this mean in practice? In workplaces where the Act applies, if the certified standing orders clearly prohibit simultaneous employment, then working for another employer can legally count as misconduct. Employers may then take disciplinary action, provided they follow the prescribed procedure. Key judicial decisions that shape this area of law. First, the Supreme Court case manager, Pyarchand Kesarimal Panwal Beedi Factory versus Omkar Laxman Thanj and others, AR 1970 SC 823. The court held that a subsisting contract of service with one employer generally bars employment with another, unless the contract specifically allows it or the employer consents. This remains the foundational authority for contractual exclusivity. Second, in M. Neelakandan versus the Presiding Officer Labor Court, the courts upheld dismissal where certified standing orders expressly prohibited dual employment, and the employer had followed due process through a proper domestic inquiry. The key takeaway is this: employers can discipline or dismiss for moonlighting, but only if their contracts or standing orders clearly prohibit it, and if they follow fair procedures. Without procedural fairness, courts are quick to step in. In the Arvind Mills and Manubhai Gordhandas line of cases from the 1950s onward, Factory workers dismissed for holding double employment had their dismissals upheld, especially in the context of Section 60 of the Factories Act. Across later state and high court decisions, a clear pattern emerges. Employers may discipline for dual employment when standing orders or contracts expressly prohibit it. At the same time, courts have been unwilling to enforce broad post-employment restraints, striking them down as unreasonable restraints of trade. The lesson is straightforward. While the law supports exclusivity during employment, it strongly resists restrictions that continue after the contract ends. When it comes to moonlighting, the law applies a few practical tests. First, is the worker covered by the Factories Act or standing orders? If so, statutory restrictions kick in, giving employers stronger enforcement powers. Second, does the contract itself contain an express prohibition, like a whole-time service clause? If yes, courts usually treat moonlighting as a breach, provided the clause is reasonable and limited to the employment period. Third, does the outside work create a conflict of interest, expose confidential information, or involve client solicitation? In such cases, employers have a clear, protectable interest, and disciplinary action is more likely to hold up. Finally, is the restriction extending beyond employment? Here, Indian courts draw the line. They are generally hostile to post-employment non-competes under Section 27, except in very narrow situations like the sale of goodwill. In short, enforceability is strongest during employment and weakest once the contract ends. What employers can lawfully do. When it comes to managing moonlighting and dual employment, employers must rely on lawful, enforceable contractual clauses. First, a whole-time or exclusivity clause. This requires the employee to devote their full working time and attention to the employer's business during the term of employment. For example, the employee shall not engage in any other trade, business, or employment without prior written consent of the employer. This is valid because it applies only during employment, not after, and is less likely to be struck down under Section 27, as long as it is reasonable and specific. Second, a confidentiality and intellectual property clause. This prevents employees from disclosing confidential information or misusing trade secrets. It also ensures that inventions or innovations created during employment belong to the employer. Courts strongly uphold such clauses because they protect genuine business interests. Third, a conflict of interest clause. Here, employees must disclose any secondary work or gig engagement and obtain prior approval. Importantly, the approval can be refused only where a genuine conflict exists, for example, data security concerns or impact on official duties. This approach balances protection for the employer with flexibility for the employee, reducing litigation risk and preserving workplace morale. In short, enforceable clauses, when drafted carefully, give employers legal protection while also maintaining fairness in the employment relationship. To effectively address moonlighting, employers should adopt clear policy and enforcement measures. First, introduce a well-defined moonlighting policy. This should clearly outline prohibited activities, the disclosure process, approval levels, and periodic review timelines. Second, make disclosure mandatory. Employees should declare at the time of hiring and provide periodic self-declarations, annually or whenever required. Third, establish a fair investigation protocol. This means issuing a charge memo, allowing the employee to reply, conducting a domestic inquiry, and finally passing a reasoned order. Without due process, any action risks being overturned in court, possibly leading to reinstatement or compensation. Fourth, provide IP and confidentiality training. Employment contracts must include clear intellectual property, assignment, and confidentiality obligations, so employees know their responsibilities. And finally, adopt proportionate monitoring. Employers can review access logs of business systems or even check PF or UAN records to identify multiple employments, but this must be done with proper data privacy safeguards. HR systems should be used responsibly, in line with data protection laws, and with employee consent or legitimate interests. Taken together, these measures give employers both preventive and corrective tools to handle moonlighting while remaining fair and legally compliant. What employees should know about moonlighting? For employees, there are a few important things to keep in mind when it comes to moonlighting. First, disclosure is always the safest path. If your employment contract requires prior consent for outside work, make sure you obtain it in writing. Silent or undisclosed moonlighting can lead to disciplinary action. Second, if you are working in a factory or as a workman in an establishment covered by standing orders, remember that double employment may be legally prohibited. Never assume side work is automatically permissible. Third, even if you do have consent for secondary work, confidentiality and client solicitation rules still apply. You cannot use employer data, work products, or solicit clients for your side business. That would be actionable misconduct. Finally, if you are dismissed for moonlighting, always check whether the employer followed proper disciplinary procedure and standing orders. If not, you may have remedies before labor courts. In short, transparency, compliance, and respect for contractual obligations are key to avoiding legal risks with moonlighting. Real-world examples and recent industry practice. Recent industry experience shows us how companies are tackling moonlighting in very different ways. In 2022, Wipro terminated nearly 300 employees for undisclosed dual employment. They used internal system logs and even UAN records to detect moonlighting. This proves that companies can and do take strict disciplinary action when side jobs are hidden. Infosys, on the other hand, adopted a mixed approach. While they warned employees against moonlighting, they also permitted controlled gig work in certain cases, but only with prior approval. This shows how some firms are rigid, while others allow flexibility through disclosure. The big lesson for HR is clear. Inconsistent corporate responses have led to litigation and even negative publicity. The best practice is to have a transparent, consistent moonlighting policy backed by a fair disclosure and approval mechanism. This balance protects the company's interests while preserving employee trust. When it comes to moonlighting disputes, both employers and employees have legal remedies available. For employers, action should always begin with the internal disciplinary process. This means issuing a charge memo, conducting a domestic inquiry, and imposing penalties only if misconduct is proven beyond reasonable doubt. If principles of natural justice are not followed, dismissal can easily be challenged. Employers may also seek civil remedies, such as injunctions from civil courts, to prevent misuse of intellectual property, confidential information, or client solicitation. Termination of employment is possible where contractual clauses are breached and the inquiry supports it. But employers must anticipate labor court challenges, as employees may allege unfair dismissal. For employees, if dismissed, an employee may first raise an internal appeal if provided in their contract or standing orders. They can also approach the labor authority or industrial tribunal, especially if they are classified as workmen under the Industrial Disputes Act. In cases involving public sector employers, or where procedural unfairness is alleged, employees may even file writ petitions before the High Court. Courts have, in many cases, reinstated employees where inquiries were found defective or biased. The key takeaway is that both sides must act carefully and within the framework of due process, because procedural lapses can decide the outcome of a moonlighting dispute. For corporates and startups, handling moonlighting requires balance, not emotion. First, don't react impulsively. Instead, create a reasoned policy that reflects both business needs and labor law realities. Second, be transparent. Publish a simple disclosure and approval workflow so employees know what is expected. Third, protect what truly matters: confidentiality, intellectual property, client non-solicitation, and duty of care, rather than imposing blanket bans on outside work. When disciplining employees, always follow procedure. Ensure natural justice, maintain audit trails, and document inquiries. This reduces the risk of reversal at labor courts. Train your managers too, because many disputes arise from inconsistent enforcement. Consistency builds fairness and lowers litigation risk. And finally, consider offering alternatives like sanctioned gig programs with clear guardrails, giving employees flexibility while safeguarding your interests. The bigger picture is this: India's employment law is a patchwork. Statutory protections for workmen coexist with contractual principles for professionals. The safest path is clarity: clear contracts, transparent policies, proportionate enforcement, and respect for due process. This balanced approach protects businesses, preserves employee rights, and prevents costly disputes. For expert legal guidance tailored to your organization, connect with us at prolegalminds.com or book a consultation at meetings.hubspot.com/Shiva20. We're here to help you build policies that work fairly and lawfully. For quick reference, here are some key authorities and resources on moonlighting and dual employment. Section 27 of the Indian Contract Act, dealing with restraints of trade, along with judicial commentary. Section 60 of the Factories Act, 1948, expressly restricting double employment in factories. The Industrial Employment Standing Orders Act, 1946, with its model standing orders and schedule governing employee conduct. Important judicial precedents include Manager Piarchand Kesarimal Panwal Beedi Factory versus Omkar Laxman Thang, 1970, a Supreme Court ruling on dual employment. M. Neelakandan versus Presiding Officer, a Madras High Court decision enforcing standing orders on double employment. And from industry practice, the well-known enforcement actions by Wipro and Infosys provide modern corporate examples of how moonlighting policies are applied in real life. Together, these authorities give you both the statutory and practical framework needed to analyze moonlighting disputes. Need a ready-to-use policy or defense strategy on moonlighting? If you're an HR leader, general counsel, founder, or people manager and want a tailored moonlighting policy, enforceable contract clauses, or support in handling disciplinary action, Pro Legal Minds is here to help. We assist with drafting legal documents, employment agreements and standing orders that stand up in court, designing workflows, practical disclosure and approval systems tailored to your organization, representation in litigation, defending or prosecuting cases in domestic inquiries, labor courts, and civil actions for confidentiality or IP misuse. Contact Pro Legal Minds today. Visit us at prolegalminds.com. Book your consultation at meetings.hubspot.com/Shiva20. WhatsApp or call us at 949-405-1717. Pro Legal Minds, helping you protect your workplace with clarity, compliance, and confidence.